Good morning. May it please the court. Reserving 4 minutes for rebuttal, I represent Joseph Kelly, who was convicted of sexual battery with great force and aggravated battery. He's now serving a sentence of life imprisonment. We've raised on appeal a number of issues that affect the fairness and ultimate outcome of his trial, including a plethora of inadmissible hearsay focused on the status of the victim, the identification of the victim, and moving to a series of prosecutorial misconduct. The prosecutor essentially created this case as a plea for sympathy on behalf of the deceased victim, a victim who was dead not because of any criminality whatsoever, but the jury was not given that clarity. Third, we've sought a double jeopardy vacation of one of the convictions for the sexual battery with great force and aggravated battery being prohibited by the constitutional protection against double jeopardy, and we've raised a sufficiency of the evidence issue. Moving to the first point, which is the use of hearsay to establish serious material elements of this offense. And it really boils down to three aspects. One is using the victim's statements when there was no demonstration by the prosecution, nor sufficient findings by the judge that the elements for admissibility of spontaneous or excited utterances was established. Essentially, no determination and no factual outlay as to the time reference between the alleged offense, a sexual battery, and the reporting of the information. No testimony, including video, reflecting when the charged offense occurred and when the victim's statements were heard. And that is a material precondition for admissibility of spontaneous or excited utterances. That was simply not established in this case.
What about the tense of the verb that the victim is alleged to have used? He's raping me, he's beating me, so it indicate that it was contemporaneous with the actual crime.
And certainly that's an argument made by the state. We do recognize the evidence is in conflict and the jury can make that determination as to what the requirement is. But this is a judge requirement. And here, that he is raping me in the context of no video reflecting the defendant being in the presence of the victim at any of the time of the assault undermines that characterization.
Does the fact that his fingerprint or thumbprint is found on her eyeglasses and there's DNA evidence linking him to her not provide that link?
Not at all, Your Honor. And this case was not a defense based on Mr. Kelly saying, I don't know what you're talking about. Mr. Kelly's testimony, which could be believed or disbelieved by the jury, was that it was consensual sex. Two homeless individuals. She sought money, and she had money on her possession.
I thought you said a moment ago, Mr. Cuny, that there was because there was no video, there was no time frame connecting her statements to him.
Correct.
But why? I'm not sure I understand why the thumbprint and the DNA evidence under the fingernails would not at least support that question going to the jury.
To the extent I misspoke, no time frame connecting Mr. Kelly to the events. The video reflects when the two of them essentially meet up. He's on a bicycle, she's homeless, they hang around the Walmart.
But when you say there's no evidence connecting him to the events, he doesn't dispute that there was a sexual encounter. Isn't
Correct.
The question purely one at that point of, was it consensual or not?
No, Your Honor, two things. Consensual is one of the issues, but the second aspect of the I've been raped or I'm being raped aspect is the issue of whether, her statements are usable. We have evidence reflecting when the two of them essentially encountered one another. There is no testimony, no video reflecting when that occurred in relation to when the sexual battery, sexual activity occurred, and the time frame on that video between when the two of them connected up And when the statements were heard, the muted statements, help me, is uncertain on this record. The record doesn't reflect when that time was. We don't know if it was 20 minutes, we don't know if it was 30 minutes, we don't know, and the state did not present any evidence showing that there was no time for reflection, that it was an immediacy. And that leads to another aspect, is this case, as the court understands from the facts, the victim died overseas having nothing to do with this offense at all. And the prosecution attempted to prove the identification of the victim through classic hearsay. Hearsay that is not allowed to establish that. There was no person who knew the victim to say, yes, that is in fact the individual. A death report was utilized to establish that a person named Mary Medoff died, but no connection between the Mary Medoff of this offense and the Mary Medoff who died. And the fact is that underlying document, although it may be admissible as proof of death, is not admissible to establish that the Mary Medoff is in fact the person who died, who's the victim here, and that is the hearsay connection. We've raised the cases of Walden versus State as well as Holbrook versus State, which make clear that the name of the victim, the statement of an identification of a person by another, is not admissible as an exception to the hearsay rule. And here, given the fact that the prosecution did not establish who the defendant allegedly raped or had the sexual battery with, the evidence, as we point out in point 4, was simply insufficient to establish the offenses of conviction, since that evidence was not usable, and it was objected to significantly. Pretrial motion in limine, hearing renewed during the course of the trial. And that hearsay was essentially used routinely by the prosecution to establish a case where the evidence was otherwise inadequate. And we also cited the Florida Supreme Court case of Conley versus State that we believe is directly on point with regard to the statements to the 911 operator. The statements come from, not from the reporting victim, but from an individual, the Walmart supervisor, who sees what's going on and reports to 911, and then the paramedic offers extensive testimony that even the paramedic testified was not relevant to the medical condition of the individual. Under the 90.803(4), which is hearsay statements for medical diagnoses, where the statements are not pertinent to the medical diagnosis, that exception does not allow rampant hearsay to be used. And finally, I have raised and pointed out the in-court identification of the victim. Here, the detective, Detective Ramos, had no idea who the victim was, did not know the victim individually. His testimony was hearsay. The driver's license was hearsay. We've cited the case of Holbrook versus State out of the 4th DCA as reflecting that evidence, if essential to establish the convictions, is simply not admissible. And there is clear prejudice in this case. We've also raised in point 2 a series of prosecutorial overreaching, and it really revolves around denigrating the defense as well as impugning the integrity of the defendant who testified and appealing routinely to the sympathy of the jury. Those statements by the prosecution, both in examination and on closing, were repeatedly the subject of objections, and they were sufficiently significant in this case that they did turn a case of slight evidence into a case of an appeal for sympathy for a now dead victim. Also, we have challenged, as I mentioned in opening, the dual convictions for sexual battery with great force and aggravated battery. the case of Lee versus State, first DCA, that sets out the test of same transaction versus distinct acts. Here, the evidence reflects one encounter, sexual battery, whether consensual or not, and the attack, one encounter, no testimony or evidence reflecting there was any time distinction, same victim, same place, same time, and the elements for sexual battery with great force and aggravated battery are identical. That violates the double jeopardy concerns, and the court should vacate the aggravated battery conviction as being violative of the double jeopardy clause. And the cases we've cited, the Harris versus State case, uninterrupted set of facts that prove both offenses that have the same elements, and the closest case on point, Morrison versus State, deals with an attempted sexual battery and a battery, and the court there said the underlying offenses are identical. One is a lesser of the other, and that warrants a determination that only one conviction is allowed. And finally, we have raised a challenge to the sufficiency of the evidence under the Schrader versus State case, a decision of this court, where there is no affirmative proof of non-consensual sexual activity and a defendant testifies as to consent. There is simply insufficient evidence to establish the non-consensual nature of the sexual activity. For those reasons, we ask the court to vacate the convictions on insufficient evidence and order a discharge, or for evidentiary reasons, order a new trial, and above all else, vacate the aggravated battery conviction as violative of double jeopardy.
Mr. Kinney, before you sit down
Yes,
on that
Judge.
last point, I guess if we reject the argument as to the evidence that came in, wouldn't the statements that she provided, that after attempting the sexual battery and he was unable to perform and then he expressed some anger by beating her, and that seemed to be, I'm characterizing it in a certain way, but wouldn't that be sufficient to sustain the two convictions? Because you've got what she said was grabbing her, pulling her, hitting her before the sex act or the attempted sex act, and then you have his inability to complete the sex act, and then he's either enraged or angered and he hits her some more. Wouldn't that be enough to sustain both?
It would not, Your Honor, for the very reason that her truncated evidence, again coming through hearsay, but assuming the court allows that, has no reference whatsoever to the consensual nature. She is not asked and does not offer any statement about, no, I did not take his money in return for sex. And after all, a voluntary sexual encounter can turn violent, and that does not turn that episode into an unlawful sexual battery. So since the state relied on her statements, again, hearsay statements, but coming in through others, and there's no testimony whatsoever about her not acceding to or being willing to have sexual conduct with him, it may satisfy the aggravated battery section, since there's clearly testimony that she did not agree to be beaten by him, although he did have another explanation and the jury's entitled to evaluate that. But no testimony whatsoever on the consensual nature. The only evidence is Mr. Kelly saying it was consensual and this is why. For those reasons, we ask the court to enter an order as requested. Thank you, judges.
Thank you, Mr. CUNY. May it please the court, Peter Koklanis for the Attorney General's office. This is not a case of slight evidence. This is a case of overwhelming evidence of multiple types from multiple sources. As to the first issue regarding the hearsay, each instance of hearsay had multiple exceptions that applied and came in through multiple witnesses in different contexts, making it all cumulative. As to Mr. Williams, he's raping me, he's beating me, he's raped me, he's beaten me. These are textbook excited utterances and spontaneous statements. In fact, they're some of the strongest examples of those you'll find, indeed stronger than every single case that was cited. This victim was in agony. She had a level of injuries that is not shown and was not matched by any of the cases that were cited. She had broken ribs. She had fractures in her spine. She had fractures in her vertebrae, fractures where the ribs connect to the vertebrae, a collapsed lung, which the doctor testified could be fatal, and bleeding in the lung. She also was in shock, physical and mental. She had a nasal fracture, a deviated trachea, and an eye rupture and bruised and swollen orbitals. This victim was in agony, and if this isn't an excited utterance or a spontaneous statement, nothing is. I'd also point out that you don't technically need an exact time frame, particularly under injuries like this. Injuries like this, you're going to be under the stress or the excitement of the event, regardless of whether the rape ended 3 minutes ago, 7 minutes ago, 13 minutes ago. You're still...
For spontaneous statement, though, wouldn't you? For excited utterance, or are you saying...
It can still be immediately thereafter, and I would argue that with injuries like these, the frame of immediately thereafter is going to be wider. I'd also point out, if you absolutely need a time frame, you can find a time frame in that video, which shows a lot. You can find that the defendant stands up and walks away from the pallet area at 12:38 a.m. He then leaves the victim. She's by herself, but obviously at this point in time, the victim doesn't know exactly where the defendant is. She doesn't know if he's just behind the pallet, going to come back any second, or if we know that he's walked down the side of the Walmart because we can see it in the video, but she doesn't know that. It takes the victim approximately 4 minutes to stand up from those pallets. Within 1 minute after that 4 minutes, the Walmart employees approach here, which means she's yelled and gotten their attention sometime within that 4 to 5 minute time frame. So you can put a time frame on this. It's 4 to 5 minutes from the time the defendant left her side. And she, again, doesn't know if the rape's over or not, because he's been raping her for over an hour. So is he going to come back? Is he going to pop out at any minute? Did he just leave for a second? She doesn't know. So these are present sense. The rape is ongoing for her. In fact, based on this level of injuries and this level of excitement that the victim described, she's naked, she's running into the arms of this Walmart employee. I would argue the trial judge would have abused discretion not to admit this under one of the multiple hearsay exceptions. And there are other hearsay exceptions that apply. In addition to 1 and 2, which are focused on the most, 3, a statement of then existing mental, emotional, or physical condition could apply to this and to the 911 call and to the statement to Ms. Rapine. Also a statement for medical treatment. She obviously needs medical attention. Now,
but, the appellant has impugned the application of that not everything stated was for the purpose of, or could be construed as actually contributing to a diagnosis.
Are you thinking more the paramedic or the 911 call? Because I would argue...
Henderson.
I would argue most, if not all of them, can. Obviously, the stuff about being beaten and raped obviously applies. The only debatable ones were that the one about him losing his erection, for example, at first glance that seems not relevant to medical treatment, but I would argue that it actually is. It shows why the situation ended. It also shows, if you read between the lines, that he did not ejaculate, which is relevant to medical diagnosis. In fact, one of the cases, the name's escaping me, in one case, the victim testified that a person ejaculated and sprayed semen in her face. The court in that case found that was relevant to medical diagnosis. Now, why would that be? They don't spell it out, but obviously you're exposed to pathogens, you're exposed to potential STDs. So the fact that the defendant in this case didn't ejaculate says less risk of STDs and so forth. It's relevant to treatment. It also explains why you would expect to find less damage in the vaginal area, which was ultimately found. And even if it's not, even if you don't like that argument, well, guess what? She's still excited at that point. So it all could still come in under an excited utterance or spontaneous statement under that, because the paramedic gets there shortly after he's called, within just a few minutes. So I'd argue she's still in an excited state at that point. As to the statements in the 911 call, I would point out that, first of all, they are admissible arguably as a present sense impression or statement for medical treatment made by Ms. Rapine on behalf of the victim, who obviously didn't have her own cell phone and was having trouble speaking, couldn't really get her own help. So arguably on that basis. Also, there are 2 to 3 times where you can hear the victim's own voice in the 911 call. If you turn it up and listen hard, and that's very important because the specific things you hear are you hear the victim say 52, it's kind of grumbled when she's telling her age. So that comes in directly from the victim's mouth. Then Tanya Rapine repeats it to the 911 operator. You also hear the victim say her own last name, Madoff. You can't hear her say Mary, her first name. Tanya Rapine repeats Mary. Then you hear the victim say her last name. They say, what's your last name? You hear the victim's voice, Madoff. Then you hear Tanya Rapine repeat it, Madoff. Then you hear the 911 officer repeat it back. You hear it 3 times. So that comes in directly from the victim's mouth as either an excited utterance or a statement of her name, which also is admissible directly under the hearsay exception that I supplemented with the statement of family history under 90.804, which is the unavailability exceptions. And so any instance of her name is covered by that. It's also, I would argue that courts treat names and identification as non-hearsay, really, because if every time you tell someone else's name, it technically is hearsay. That's why I supplemented those cases, kind of arguing that, you can't really identify people without relying on hearsay. Either they told you their name or you knew their name because they originally told you, but it's always hearsay. As to the death certificate, I would argue that was stipulated to. So as far as them arguing, well, we don't know whose death certificate this is, well, they stipulated that the victim was dead. So that makes it relevant and links it up to that. There was no real dispute that she was dead. They also, if you wanted to match it up, you could look at the name, it matches, the death certificate matches, the date of birth also matches, and if you look at the address of that death certificate, it's a Fort Myers address. I didn't specifically compare it to the driver's license, but it's enough circumstances that suggest this is the same Mary Madoff, same age, same date of birth, same city, same name. And again, it's stipulated too. I'd also emphasize that any of these instances are cumulative. She tells the raped and beaten to the first Walmart employee, then to the second Walmart employee, then in more detail to the paramedic. So if there's any technical one that you want to argue was error, well, it's cumulative. I'll also make a kind of a global harmless error argument that could apply to any of them. This is one of the strongest cases of harmless error in that the defendant is literally caught with the victim's blood on his hands, feces all over him, including on his boxers, which were inside his pants. The victim's blood DNA was literally found on his penis. And the defendant's DNA, likewise, is found under the victim's fingernails and on her nipple. And she is obviously beaten brutally. So there was really no doubt about who did this and no reasonable doubt that it was consensual. I want to also talk about the video for a second because I don't know how closely you all watched it, but both the judge and the prosecutor properly pointed out that there is violence in that video. Yes, it's hard to see, it's grainy and blurry, but if you really watch that hour and a half with eagle eyes, you can confirm what the prosecutor argued, which is there are multiple instances of violences. The ones that I'll point out to you are there's at least 4 instances where I saw the defendant grab her by the legs and pull her forward. There's at least 4 instances where you can see his body kind of cock back and quickly whip forward, consistent with punching. And you can even see 2 instances where you see his elbow cock back, and one that I found really notable, where you see the top of his forearm cock back, and it's just an outline, obviously, because you can't see his details clearly, but it cocks back, and then he whips forward. There's another instance that the prosecutor pointed out, and the prosecutor threw some time citations in his rebuttal argument. If you want to look at those, you can. But there's an instance where the victim appears to be pushing him back with her feet, and he falls, the defendant, onto his butt, suggesting she's trying to push him away. There's another instance where the victim and the defendant both slide and fall off the pallet, and you can clearly see the defendant pick her up in both arms and put her back on the pallet. She's just kind of motionless, limp at this point. Notable is that everything I've described occurs within the first 30 or so minutes of the video, completely decimating the defendant's testimony that all this was consensual, and only at the end did I get mad when she tried to take the money, and then I blew up, punched her a bunch of times, and then left. If that were true, you'd only expect to see violent activity at the very end of the video. It also contradicts the defendant's testimony in that at the end of the video, he's on top of her, which corroborates, first of all, you can see him on top of her multiple times in the video, and you can see her legs kind of up around where he would be in between her legs. So you can confirm that a sexual act happened, which means it's not all hearsay, which, contradicts those cases that if it's only uncorroborated hearsay. Well, it's not uncorroborated hearsay. But also, at the end of the video, he just kind of gets up, stands, and then leaves. There's nothing consistent with standing and then her taking it and then beating her. He just leaves. And then the victim immediately gets up. So obviously all these injuries we see on her were caused by what you see in that video. As to the prosecutorial misconduct, I would point out that certain cases, a little bit of emotion, a little bit of tension is going to be unavoidable. Jurors are human beings, witnesses are human beings, and when you're dealing with cases involving brutal rape, there's no way to whitewash all emotion out of it. The question is, did the prosecutor improperly fan their desires to drown out all rationality? No, he did not. You can't avoid a little bit of sympathy in a case like this, particularly where the element is great bodily harm, permanent disfigurement. Human beings are going to be sympathetic when they hear about injuries of that nature, which by necessity we have to prove. The prosecutor also tracked the elements. He used the exact language that the witnesses used when he quoted the phrase elephant man and so forth. That's the exact phrase that the witnesses used, because that's how swollen her face was. And elephant man is just a disfigured person. An element of great bodily harm is permanent disfigurement. So that is the metaphor that these witnesses used, and that is the metaphor that the prosecutor repeated. So that was completely proper. As far as witnesses getting a little emotional in their demeanor and the prosecutor, saying, "Are you getting emotional?" That too was proper. I would agree that there is a point where it could become improper, but under this case, first of all, it'd be harmless. Second of all, it was proper because witnesses should be allowed to explain their demeanor if they are having trouble testifying. Remember that the weighing the evidence says, did the witness seem to be honest and straightforward in their testimony? Did the witness seem to have an accurate memory? Well, if they're having trouble testifying, getting choked up for whatever reason, they should be able to explain that it's not because they're lying, trying to think of things, trying to remember. It's not because they're having trouble remembering. It's because they're having an emotional reaction. And that also is relevant to the jury assessing their demeanor. An emotional witness is usually an honest witness. People aren't good at making up emotions and acting. So if they're having an emotional reaction, that shows that this was a traumatic event that was very memorable to them, and it allows the jury to assess their credibility. So overall, it was relevant and nothing improper happened. As to the double jeopardy, I would like to emphasize that each has an element that the other does not. And my understanding of Blockberger is that if we meet the Blockberger different elements test, we're done. It doesn't matter whether they're technically separate episodes, distinct acts, whatever. It doesn't matter because they have different elements. And the different elements here, which is directly on point in the HIP case that I supplemented with, which was a sexual battery with great force case, is that first of all, aggravated battery has the separate element of actual great bodily harm, which isn't required in sexual battery. It also has a different element that's kind of implied, and it's easy to miss. It has a heightened mens rea. You have to actually intend to cause the great bodily harm. So I call that malice for short. You actually have to maliciously be beating them with intent to cause great bodily harm. You might call that specific intent or whatever. Just there's a heightened intent, whereas the sexual battery crime has no malicious intent required. You just have to use force, period. In that sense, it's more of a strict liability or general intent crime. You don't have to intend to cause the harm, and you don't certainly have to actually cause the harm. So those are two different elements. And then even if you have to go into the distinct acts, as we argued in our brief, there was certainly sufficient evidence of that. The defendant himself cast it as two different acts. There was consensual sex followed by, I got angry about the money and beat her. Well, the state's argument is very similar, except we don't agree that it was consensual. We're saying it wasn't consensual, and then you did get angry about something, but it wasn't the money, it was impotence. So, there's certainly competent evidence to support distinct acts in there, and also based on the victim's hearsay as well. And as to the force issue, the sufficiency of the evidence, first of all, it's not a circumstantial case. The victim's hearsay, calling it a rape, did come in, and that doesn't make it circumstantial. Hearsay and circumstantial are two different doctrines. If the hearsay is admissible because it's reliable under the various exceptions, well, that's affirmative direct evidence that she was raped of lack of consent. Even if you want to go outside of that, there's plenty of evidence that it was not consensual. The feces, which I mentioned, obviously that doesn't happen during consensual sex. That's not normal. And the fact that it's on his boxers, again, suggests that she was brutally beaten, and that's why she defecated herself. Same thing with the blood on his penis. Same thing with just the overall scope of the injuries. And I want to point out a few of the injuries that were affirmatively inconsistent with his story that he just punched her a bunch of times. You saw the bruising around the neck in the pictures. That was uniform bruising. Also the deviated trachea. That's much more consistent with choking or holding down choking. It's not consistent with punching, which would be like bloody bruises. And punching wouldn't normally deviate the trachea. Also the bruising on her knees, that was more consistent with a situation of forced oral sex. I mean, did he punch her in the knees? Why would that cause bruising? And then, of course, just the general scope of the injuries. They were everywhere, bruising on her back, front, sides, face. You know, that's more consistent with a drawn-out battering from every angle, not just a flurry of punches at the end. So at the end of the day, his testimony was not even remotely reasonable. Any issue was harmless, and we'd respectfully ask you to affirm if there's no other questions.
Thank you, Mr. Koklanis. Mr. Cuny?
I ask the court to consider, in evaluating the propriety of the conviction, the fact that the 9/11 call that became essential in this case is a call from somebody else, not the victim, Ms. Rapine, who is simply relating what she says. And in the process, the substance of what she's saying, not under any excitement, not under any event that caused her stress. She is narrating what she observes, and that is inadmissible to come in. Certainly she can testify as to what she said, but the 9/11 tape is classic hearsay. And the state argues that identifying somebody by their name is not hearsay because that's how people are known. The Holbrook case discusses that extensively. In Holbrook, the court said, where you know somebody as knowing them, that's different from being identified by an individual or seeing a hearsay driver's license. Here, that identification comes from the detective as saying, this is what she said, and then trying to connect it to the death report, not a certificate of death. The connection to this Mary Madoff and the Mary Madoff who's the victim is what is the hearsay in this case. That was the essential link to the entirety of this case and was erroneous. And additionally, Your Honors, we have pointed out in the context of the offense. The state argued at trial that there's separate offenses, the sexual battery, the battery itself. Yet in the Attorney General, the state's on appeal presentation of this, it makes clear that according to the state, it's a 1 or 1.5 hour continuous episode. There is no distinction between the conduct evincing the sexual battery and the aggravated battery. For those reasons, we believe the evidence reflects the allegations in the charge, as well as the evidence reflects that a continuous criminal episode involving the same elements for which double jeopardy applies. Thank you, Your Honors.
Thank you, Mr. Cuny.